Good afternoon, guys. My name is Alena Shautsova. I'm an immigration attorney from Brooklyn, New York. And in today's live event, I would like to share with you some really good news. So let me first check out that everything is working and we are actually online. Let me see if it's working. Yes, it's working. Great, I can hear myself. So the reason why I would like to have this live is to talk to you about a couple of very important news that happened during this week, and of course discuss Citizenship for Essential Workers Act in detail. Why? It's because this act is very broad. This law, it will help many people. And I believe that you should know about that just because it's great if it's actually going to pass. So thank you very much, guys, for joining me. Hi, Donovan. Hi, Fran, Amir. Very nice seeing you all to join me. So let's talk first of all about some news that happened that may be relevant to you guys. Well, first of all, Biden revoked Trump's healthcare proclamation. If you recall, Trump's health proclamation was the proclamation that would require anybody who would like to come to the United States to show that they have healthcare insurance. And it's easier said than done, because what happens is that some people would not be able to get the healthcare insurance just because they're overseas. Right? So it would be very difficult to get for them health insurance. And of course, it's much easier to get health insurance for somebody who is already in the United States. And for that reason, that a proclamation was very unfair. It was very difficult to comply with it. And amazingly, finally, Biden revoked it. So now, if you're sponsoring your parents, your spouses, your children, sisters, brothers, you don't need to worry about the health care proclamation anymore. It means that you may safely follow consulate instructions for the immigrant visa, and you don't need to comply with those additional instructions and requirements that were set under former President Trump. Hi, Jermaine. Thank you, Mizan. So this is one news I wanted to share with you. Another thing is that you may have heard that USCIS started to waive green card interviews for some applicants. It's great news because, again, during the Trump administration, what happened is that USCIS started to invite for the interviews everyone, basically, regardless who you were sponsoring. Were you sponsoring your parent? If you received if you were filing for the green card based on asylum or on some other grounds, even fiancés who have approved fiancé petition, everybody was called for the interview and employment. And now it seems USCIS is reverting back to its old policy when they do not invite you for the interview if you are sponsored by your employer, or if you are a special immigrant juvenile, or you filed for the green card based on VAWA and there are no additional questions towards you, for example. So that's great news. And of course, also it's great news for asylum seekers and those who would like to file for their family members after they want asylum, so-called I-730 petitions. It seems that interviews for those people will be waived as well. So very good news. Now, one more thing I wanted to mention is that for those of you who have Russian family members who are seeking to come to the United States on immigrant visas, U.S. consulate in Russia stated that they will resume giving immigrant visas through July 16th. I know that we received news previously that the visas, immigrant visas or non-immigrant visas, are not going to be issued in Russian in Russian US consulates anymore. But now we got news that they will resume, just because of the way the Moscow changed the deadline when the embassies will not be able to hire foreign workers anymore. And because they moved the deadline, you also can now enjoy, if you can call it this way, an ability to receive a visa in Russia. So that's good. I believe that's good. All right. So now let's talk about this big news that I wanted to talk to you about. It's Citizenship for Essential Workers Act. Why I think it's a big news is just because recently it seems both sides came together that it finally has to pass. And I'm sure because other countries are passing similar laws, there is some pressure on US senators and congressmen to keep up. Well, I hope so, right? So Citizenship for Essential Workers Act, I believe, was introduced March 15th, a couple of months ago. And I haven't really spoke much about that just because I wasn't sure where it's all going, if it has any sort of ability to become real. And guess what? It seems that it does now. What's great about this law is that it's very, very broad. It's going to basically cover everybody who worked during the pandemic. So I'm going to now list the areas of work that people who were employed during the national pandemic and earned some income working in those areas will be able to file for the green cards if the law passes. Healthcare industry, emergency responses, sanitation, restaurant ownership, food preparation, vending, catering, packaging, food services and delivery, hotel industry and retail, fish, poultry and meat processing, agricultural work and labor, commercial and residential landscaping, housing, residential and commercial cleaning services, healthcare, home workers, those who also provide assistant work for assistant living places, family care, meaning nannies, transportation, construction industry, warehouse workers, logistics, laundromat services. Okay, so if you were a delivery person, if you were a taxi driver, if you were a nanny, a construction worker, during which period of time? The time of the National Emergency Proclamation, which is, I believe, starting from March 13th, 2020, until the national emergency ceased to exist. And if you were working or earned income during that time, if the law passes, you will be able to file for the green card. You need to show that you've been in the United States since January 1st, 2021, and you are in the United States while you're making this application and you haven't left the United States for a prolonged period of time or 180 days, you will be able to file for the green card. A lot of the grounds of inadmissibility will be waived. The best part, which I personally liked, is that even if you had an order of removal or deportation against you, or order of voluntary departure that you didn't comply with, you will not have to file a motion to reopen, but file for this green card, and if it's granted, you will be able to, basically the order of removal will be automatically vacated. All right, so this is great, I believe. This is fantastic. If you're a relative of somebody who unfortunately passed away during the COVID and who worked during that time, you will be able to still file for the green card. All right, so that's how the law is written. Even if you're a son or daughter of the person, meaning that you are above 18, it's very, very important, above 21, it's very, very important. Now, what's interesting also is that the same law says that if you are a spouse, daughter or parent of an armed forces member or including National Guard, you also will be able to file for the green card. Finally, there is a law that actually says that relatives or family members of the servicemen should be able to get the green card. Then the law says that there will be some fee that needs to be paid, and interestingly, for the first time, it says that the fee, you would be able to pay the fee in installments. Amazing, right? Because previously, I do not know any of the applications for any immigration benefits that would allow installments to be paid. So that's very good. And that's what it is. What else I wanted to mention? Voluntarily departure will not be a problem, which is amazing, because usually if you have an order of voluntarily departure that you didn't comply with, you will be prohibited from filing for any relief for 10 years, right? And here it seems it's not going to be an issue. So we have this great law. What's happening with it? We have this great proposal. Well, right now, it travels through different committees, and from what I understand, we have very positive feedback by both the Democrats, of course, who introduced this act, and Republicans. So watch out for it. It may be part of the reconciliation budget law, and if it makes it, it's going to cover millions and millions of people. I believe they estimate 5 million of people, but frankly speaking, pretty much every immigrant I know will be covered by this act. All right. So this is the news I wanted to share with you. I hope you find this helpful. And now, guys, if you have some questions, I'll be happy to answer them. Let me see. And I'm using like a new streaming system. So if I'm not seeing your questions, I'm sorry. I'm really trying to. Hi, Kafet. Hi, good afternoon. Nice to see you. You can ask about my work permit. I applied in February. They received February 9th my application, but I'm still waiting. Well, that's totally normal, okay? Some work permit applications, it's very going to take a very long time. And usually, if you have certain work permits, of course, certain work permits are not eligible for it, but most are. If you filed your application to renew your work permit prior to the expiration of the old one, your old one will be automatically extended for 6 months. And I'm not sure if your situation is covered by this automatic extension, but many situations are. So that may be something that can help you. All right. Let me see if we have more questions. Is it possible for someone who have student visa to get a green card? Well, totally, if you qualify for it. I mean, there is no automatic pass for the green card straight from the student visa. But if you have an employer who is willing to sponsor you, or a relative who filed I-130 petition for you and it's current, or you are an immediate relative, you of course will be able to get a green card. All right. But you need to have a ground. It's not just automatic that after the student visa you can file for the green card. Unfortunately, it doesn't work like this. Hi, Ramil. My brother won green card this year, but he received 4 refusals from the American visa past 5 years. This issue will affect the green card interview. Well, if he received a DV lottery, right? And previously he has, it's actually a very good question. And previously he had some denials. They will not affect by themselves his eligibility or ability to receive DV lottery visa, unless he was denied, for example, because there was a fraud or misrepresentation, okay? But if he just was denied, he tried to come as a tourist, but the US consulate said, well, you have an immigrant intent, right? We believe you want to stay in the United States. This will not affect DV lottery. This is not a problem, all right? When does this application start? If you're referring to the Essential Citizenship for Essential Workers Act, this is just a proposal. You cannot file for an application yet, but I hope, and many do, that it will be it will become the law soon. And then they will publish the instructions and the forms and how much it's going to cost, but only after it becomes the law. Just wanted you guys to know that it may be, it seems that it's a very serious opportunity and very serious proposal that may become the law. All right. Is it possible, hi Ty, is it possible for your spouse to apply for fiancé visa or spouse visa if you do have a visitor's visa? All right, only a US citizen can file petition for fiancé, just first of all, just so we're clear, right? If a person already has a visitor's visa and they are overseas, I understand, right? Is it this is fiancé visa, spousal visa if you do have a visitor's visa, and you're overseas, then of course, and you're married to a US citizen or green card holder, that person will have to submit I-130 petition for you. Is it possible for you to travel on that visitor's visa while the petition is pending? Perhaps, but you will have to be truthful at the border and let them know that you have a spouse now in the United States, and the border agent will make a determination whether or not to allow you to come to enter the United States. All right, this is how it works. This is how it works. Hi Shirak, I'm pending asylum. Applicant are eligible for citizenship and essential workers. Yes. According to the draft of the law, people who already have status in the United States are not going to be eligible. For example, if you are already a green card holder, or if you have a refugee status, but if you just have asylum pending status, this is not the status, a lawful non-immigrant status that will prohibit you from filing for essential workers. At least how I read the law. Okay, and I think I'm right. So I believe, yes, guys, you will be able to. Hi, Kafate. This was my first work permit. I'm asylum seeker, and it's almost more than 3 months. A USCIS received my application. Oh, so this is your first work permit, and 3 months passes. Well, it takes a little bit longer, I'd say. You know, you should probably follow up with your attorney to see what's happening. That's how I would say, because usually first time work permits based on asylum pending take within 60 days we receive them, you know. Yes. Hi Talsin, is it possible for someone that has pending asylum case and now have I-140 approved, can that person adjust status in the United States without leaving the country? Usually, guys, unfortunately, no. It is because, again, pending asylum is not a status. It's not a lawful non-immigrant status that you need to maintain under 245C. This is the law section that is required for you to be able to adjust status based on what's called preference category or including employment-based category. Okay, so unfortunately, adjustment of status is not going to work. Okay, in most cases, some people cite there is an old Board of Immigration Appeals decision that says that if you file for your asylum prior to the expiration of your lawful non-immigrant status and the asylum pending asylum has been pending for a very long time, now you should be able to adjust your status based on, let's say, employment petitions. There is a case like that from Board of Immigration Appeals, but I know that it's not working anymore. All right, I know that some people get advice from some lawyers saying that they can get them this adjustment. I personally stay away from it because I don't think I can. I consulted with other lawyers in New York and everybody told me that they can't, so I wouldn't file such an adjustment. That's just me. Maybe there are some magical decisions in your favor, but I'm not aware of them. I'm aware of denials in this situation. Okay. Hi Marisol, if someone had an order of deportation and did not leave but continue working for the past 22 years and paid taxes for every year up to date, would they be able to apply for the green card? Not just by itself, but if the Essential Workers Act is passed, yes, they will be, okay? if they were working in the industry. But just because they haven't left, no, they don't automatically get any relief. In fact, you know, if a person has an order of deportation, in many cases they cannot file for any type of relief except for U visa, really, all right? Except for U visa, without reopening the case and filing for adjustment of status. This is true for 99% of the cases. There are some rare exceptions when you still can file for adjustment of status before USCIS, even if you have an order of removal, but it is only if you're an arriving alien, and there are some other conditions that are met. So guys, thank you very much for watching. Really am excited because you joined me today, and hopefully I answered some of you guys' questions. I'll try to comment and answer some more of your questions. So please share this video, share the video, and stay in touch, okay? Follow my page so you will be able to join more of our live streams and hopefully learn more good news. And I hope